A very good evening, dear students. So, we are doing today the interpretation of statutes, and as you must have noticed, we are at the verge of completion of our syllabus for this subject. And 3 to 4 classes are still left, and then you will be completing the syllabus for paper 2, corporate and other laws. So, in the last class, we have discussed about the Journal Clauses Act. And today we will be starting with the interpretation of statutes. Why these two topics have been kept together? Some students might be thinking that journal clauses is altogether a different ball game and interpretation of statutes is altogether a different ball game. But very categorically, if we see, these two chapters are very interconnected and interlinked. While you will be doing this chapter interpretation of statutes, you will be thinking, okay, many of the things are coming from the Journal Clauses Act and in the Journal Clauses Act from the interpretation of statutes. Especially if you would have seen, while sir would have explained to you the meaning of may, how may can be interpreted as shall and how shall can be interpreted as may, what is the overlapping between the two. Same thing you would be somewhere doing in the interpretation of statutes also. So the basic key difference between, or rather the linkage between the both the things is that the Journal Clauses Act is a practical tool that provides definition and interpretative rules applicable to all central acts in India. Like Journal Clauses Act 1897. So in India. But if we see the interpretation of statutes, it is more so a very comprehensive approach and it provides the way to understand all kinds of those acts. In the General Clauses Act, it is an interpretative tool kind of a thing that whatever the definitions that have not been provided in anywhere, the legislature can use those from the General Clauses Act. And the rules that are provided in the interpretation of rules, interpretation of statutes, they are to be applied unanimously. आप उसे हर जगह अप्लाई कर सकते हो. Every kind of act, be it your income tax, if the mischief rule is there, then you can apply it. Or beneficial construction is there, which we use a lot in the income tax act, that you have to see it from the point of view of providing benefit. Okay, so there is a lot of overlapping as well as uh, if I say interconnection between those two. One thing that you need to take care of while doing your examination questions is that many a times you will feel that the same question can be solved through interpretation of statutes chapter also and also through the Journal Clauses Act. Carefully read the language of the question. They would be giving you generally a hint that solve it as per the Journal Clauses Act. Many a times they might not be writing it as solve it as per the interpretation of statutes, but generally when they are asking a question to be interpreted or to be solved as per the Journal Clauses Act, they will give you that. So keep that in mind, because we many times receive that question that the students in the examination conditions got confused that they had to solve it as per the interpretation of statutes or the Journal Clauses Act. So with this, I would like to tell you one more thing is since I said that we are at the verge of completion of our syllabus for this subject and as well as I think accounts also. From tomorrow onwards, we are starting for the LVRC, which is your live virtual revisionary classes, which will be aiming solely for the September 2025 papers examinations. So I request you, okay, so I'm receiving these queries. I understand that there is a bit of a overlapping between the LVC and the LVRC. So that's what I want to clarify. Look, you are at the verge of completion of these classes, and I think morning classes, some accounts classes are left as of now. In the evening, only our paper is left. That is paper 2 corporate and other laws. So, and 3A, I think 1 or 2 classes of 3A. So there will be not much overlapping in the evening, but more so in the no, in the morning also there will not be any overlapping. Will there be? Okay, three classes will be overlapping in the morning also. So I think plan it accordingly. If you are well versed with whatever you have already completed in these classes, request you to take the help of the LVRC to revise those, because we will be focusing mainly on solving of questions. So it will help you to solve those questions, and we will be focusing on all kind of questions, whether they are from your MTP, RTP or other sources. So it is focusing solely on revisionary. A student who is well prepared can solve those questions. If you are still thinking that okay, I will just revise the whole of the concepts. The concepts will be revised fully, but only with the help of questions. So while you are coming for tomorrow's class and the classes that will be ensuing further, do come prepared with a paper, pen, and everything, because you have to solve your questions. One thing is that. And second thing is the recorded lectures are provided to you for the LVCs, which we are continuing right now, and also for the LVRC classes, which will be starting from tomorrow. So for few days, request you to kindly manage your time accordingly. You have now is the time to give all your heart and soul for the preparations, since we are in July. So August, July full and August, so 2 months. So it's now revision and more revision. So I would say that from tomorrow onwards, whosoever can join the LVRC, do join. And if not, then go in for the recorded lectures. They will definitely help you a lot. So with this, if the students have any questions for me, they can ask. So I think it's either all clear, or as I say, all clear. So good evening, students. And with this, I will take a bye from you for today and hand over the baton to sir. Good evening, Shagufta. Good evening, Praveen. Good evening, my students, Imran. And good evening, Pooja, Anubhav, Dhanush, Neeraj, Pavan. Good evening, students. So, sir, please take on the baton from me and continue with the class.
Thank you for setting the context and much needed clarification which the students want during the time of preparations. Definitely, these tips are going to help you students, and nothing is better than having more and more revisions. This is very very important, right? So thank you again, Shraddha, for giving a very interesting difference, or you can say the interlinkage between these two concepts of interpretation of statutes and General Clauses Act. And I must tell you that in General Clauses Act is actually a part of interpretation of statutes if you look at it. So when the courts are interpreting the law, they need assistance to interpret it. And that is what we are going to see today in our today's class. And General Clauses act as one of the legislation which helps them in case, say, they don't find some answers to the questions in the legislation which they are interpreting, say, for example, Income Tax Act or Companies Act or SEBI Act, then there they may go back to the General Clauses Act for assistance. However, as I told you in my previous class on General Clauses, that whenever the statute is clear on things, there is no need to go back to the General Clauses Act. So these two things are complementary. They are not dissociated or independent. So I don't think that you will face any confusion between these two concepts, interpretation of statutes and General Clauses Act. So try to read them together. So it will solve your problem much easily. Okay. Now coming to this session on interpretation of statutes. But before that, we will have a quick recap of what we did in our previous class, since it is a class on interpretation of statutes, but carries forward the General Clauses Act. So we discussed broadly the General Clauses Act section wise. We saw that the General Clauses Act has got about 30 sections, And these 30 sections are arranged into major 4-5 parts, right? The first part was with reference to general definitions. Then we saw about general rules of construction as to when the law comes into existence, that is section 5. What is the effect of repeal? If a law is repealed, then what happens? What is the repercussion of that? What do you do with the repealed law and what do you do with the new law? That is something which we discussed in section 6. Then we talked about the computation of time, commencement and termination of time. These were some general understanding of topics, gender and numbers. And then we discussed a chapter specifically on powers and functionaries as to what happens in an office. And say, for example, if there is a head of that particular office, if he is not there, then what happens to his powers, whether it can be exercised by its subordinate. These are the things which we discussed in powers and functionaries. So generally, if you will see, a legislation has got 2-3 things. Okay, one, it will have a substantive thing, that is the law or the rights which has been mentioned there. Second, there would be the rules or procedure to vindicate those rights. That how do you do if there is a violation of those rights? Where do you go? How do you deal with that? Or if it is a regulation to regulate something, then what is that regulation about and how do you regulate it? These are the 2 things. Third, in a legislation, mostly you will find a authority or a body which is regulating it. And then fifthly, the penalties and related procedures. That is what, these are the more majorly 4 things which you will find in mostly legislations. In our previous class, we also discussed the structure of a legislation, how it is arranged, and we saw the application of General Clauses Act to those particular sections. Then we also saw the another chapter, that is provision as to orders, rules, etc. made under this enactment and how they will be interpreted like bylaws. And you would recollect the principle that nothing can go beyond the Parent Act. So no one can legislate anything which goes beyond the Constitution. No one can legislate anything under the company rules which goes against the Companies Act, like that. So you need to see that the law has to be within the periphery of the Parent Act. And then we also saw the provisions relating to recovery of fines and meaning, citation, etc. These are the things which we discussed in our previous classes. Now, I have a couple of questions which I am able to see in the chat box. Let me address them very quickly, and then we will move ahead with our interpretation class. So if I see there is a question which says what it means in operation in a constitutional sense. Okay. So when we say in operation, that means basically that law has been notified and it has come into operation. If the law is not yet notified, that means the law is not into force. So under the Constitution, you will see this particular word, law in force. So if law in force means that law is under the implementation. If it is not, that means it has to wait till the government brings it in force, right? So this is what has been talked about there. Now, there are certain points which you have asked, which refers to your study material. So probably I would not be able to answer it at this point in time because I have to simultaneously refer to the study material, which I don't have right now. Just a second. Okay. Another question. Okay. These are all salutaries. Good evening, everyone. Okay. So I think I have exhausted with the questions. There is only one question which I have not answered, which refers to your booklet. So let me refer to those questions during the break in the booklet, and then probably after that I'll answer. Now let me move further and talk about today's session. So the learning outcome of the 2 sessions which I am going to conduct in today and on 9th will be dealing with the interpretation of statutes. So the objective of this particular chapter is basically to gain knowledge about the need for interpretation of statutes, why interpretation of statutes is needed. Second, to explain the various rules of interpretation of statutes so that you are aware about how to interpret the legislations. Third is to describe various internal and external aids to interpretation. And the last one is to comprehend the rules of interpretation of deeds and documents. So if you will see, primarily there are two areas which we are looking at. One is deeds and documents, and the second one is statutes, right? All these will require interpretation. So this is where the outcome of your sessions are laid down. And I hope you are clear about this. Towards the end of it, you should be able to do all these particular things. That is the idea. Now, moving forward, let us understand some basics and certain aspects very clearly. So the first thing which we are looking at is statutes. So when we say statutes, it is not a statue, by the way, it is statutes. Many a times you confuse with the spelling. So statue means murti, but here statutes, when we talk about it, it is basically the legislation. Okay. And these are laws and regulations of various kind, irrespective of the source from which they emanate, right? So we have discussed already Article 13 of the Constitution of India. So refer to Article 13 of the Constitution of India. It includes many things, okay? It includes orders, it includes rules, it includes ordinance. Everything will be considered as a law. And here, when we are talking about interpretation of statutes, generally we are referring to the law of the parliament. However, it does not preclude rules, regulations. These are also included into it. So generically, we are referring the word statutes. Second is documents. So what do you mean by documents? Evidence Act defines documents. So Section 3 of the Evidence Act defines documents, and it says document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter, right? So you must have seen in some of the movies, right, that when the police inspector is investigating a crime, he goes to the crime scene or he meets the potential killer and he tries to extract the fingerprint of that person concerned, okay? And what he uses, probably a glass or probably an instrument or probably a document. And you must be seeing with the cloth he wants to, access that particular glass, and then later on. So that particular glass itself is a document which carries the fingerprint of that particular person. I hope you are able to understand the definition of the documents. It is quite broad. It includes anything. So there is a medium is of no consequence. It can be a pot, it can be steel, it can be paper, it can be a leaf, and there should be something written on it. This is basically document as per Section 3 of the Evidence Act, and it is a very broad definition. Then comes deeds. Deeds are instrument in writing or other legible representation of words or parchment or paper purporting to effect some legal disposition. So generally deeds will include transfer deed or maybe transfer of shares or transfer of property. So simply stated, deeds are instrument, though all instruments may not be deeds. However, in India, no distinction seems to be made between instruments and deeds. So generally you use this term, instruments and deeds, sale instrument or instrument of transfer of property, or you can say will, or these are all referred to as deeds. Okay. Most of the times you would have heard the term sale deed, but as per the understanding or usage, instruments and deeds are synonymously used, and there is no problem here in India. Okay. So I talked about three things. One is statutes, which you mean by laws. Documents, it includes anything which is a written thing on any medium. And deeds, basically, these are something wherein you are conveying something, some property. Either it can be intangible property, movable property, immovable property, whatever may be. Okay. So these are the three important terms you should remember in your these two classes. Let us look at classification of statutes. Now, we are talking about interpretation of statutes as well as interpretation of deeds and documents, that we will talk about it later. In terms of statutes, statutes are of many kinds. Like, for example, in the introductory remark, Shraddha Madam pointed out specifically that taxing statutes are interpreted beneficially. That is what something she said. Now, this basically means what? That different statutes have a different nature, right? And while interpreting them, the courts view that particular statute from that angle. Okay. So, classification of statutes is important from that angle. Let us try to understand what kind of a statutes can be there and how interpretation affects them. So there are certain statutes which are called codifying statutes, right? So the purpose of this statute is basically to give authoritative statement of rules on a particular subject, which is customary laws, or it can be even commercial law. Like, for example, insolvency and bankruptcy code. What it does, it tries to codify the subject of insolvency, whether it is personal insolvency, whether it is corporate insolvency. All kinds of insolvency has been tried to be included in one code. That is the objective. So it is codifying statute. Similarly, if you will see Hindu Marriage Act, Hindu Succession Act, these are all coming from the Hindu code. If you see the Civil Procedure Code, now it is Bharatiya Nagrik Suraksha Adhiniyam. That is also a kind of a code, which basically codifies certain the things and brings it together into one umbrella. That is codifying statutes. So these are codifying statutes or codes, you can say. Then there are certain statutes which are consolidating in nature. They consolidate the things together. And this statute covers and combines all law on a particular subject at one place, which was scattered and lying at different places. So this consolidating statutes becomes a codifying statute. So basically what happens is they consolidate all laws relating to a particular thing in on a subject or on a procedure. Like, for example, Indian Penal Code. So it is codifying initially, but now it is also a consolidating statutes, right? When we refer to codifying statutes, generally we are talking about something which was in practice before, but now we are trying to codify. In consolidating statutes, the statute was there. We are trying to just, consolidate all laws relating to that into one legislation. Now there are certain declaratory statutes. Okay. So it is objective of this particular law is to declare basically and clarify certain provisions, or you can say interpretation given by a court. And this is what is done by, like, for example, Income Tax Amendment Act. So it is trying to, declare the definition of house property as amended by the Supreme Court judgment. So you are basically declaring a provision or a situation through the legislation. This is called a declaratory statute. So declaratory statutes declares a particular thing. Then there are statutes which are in the nature of remedial statutes. We call it remedial statutes, and generally they provide for benefits or enforcing one's rights. The purpose of this statute is basically general welfare or for bringing social reforms. Like, for example, now we have laws relating to pavement dwellers or maybe street vendors. Right now, Supreme Court is hearing that matter. So these are basically remedial statutes, or Maternity Benefit Act, Workmen's Compensation Act. These are all remedial statutes. So generally, whenever a court will be interpreting a remedial statute, they will be interpreting generally in favor of the person for whom the law has been brought up, right? So they will have a bit of a soft corner while interpreting the remedial statutes. So you will see this is how it happens during the time of the interpretation. Then there are certain enabling statutes, right? So the purpose of this particular statute is enlarge a particular common law, and it actually enables the government to provide for more rules into it, or it provides power to the government to take certain things, like, for example, land acquisition. So it enables the government to acquire the property for the purpose of public purpose and through by way of a notification, right? So this is nothing but a enabling statute. Similarly, there are certain statutes which are disabling in nature. So they take away right, or people are restrained from doing it. Like, for example, emergency provisions under the Constitution of India is a disabling statute. It is trying to stop someone. Like, for example, Armed Forces Act is a disabling statute. So you have restrictions on the grounds of discipline for the people in armed forces because of the disabling statutes. Then you have penal statutes. So penal statutes are talking about crimes. So there may be many, either it can be penal code or it can be some specific legislation, like, for example, corruption related laws, or you can say narcotics laws, or you say smuggling act. All these particular legislations are basically penal statutes, or you say PMLA, these are penal statutes. Now there are taxing statutes. So tax is a form of revenue. You all know, who could know better than CS? So tax is a form of revenue which is to be paid to the government, and it can either be on income or it can be on direct or indirect taxes. And all the legislation which deal with income tax, wealth tax, sales tax, gift tax, etc., are taxing statutes. And tax can be levied only when it has been specifically expressed to be provided in the statute. So Constitution of India specifically mentions that no one can levy tax unless it is specifically provided in the statute. So you need to legislate, you need to have power to tax, then only you can tax. You cannot just tax by the way. Okay. Then there are certain statutes which are amending statutes. So amending statutes are there to amend any law. So you must have seen a lot of amending statutes under the Companies Act also. Insolvency bankruptcy code has been amended many times. CRPC got amended many times. So these amending statutes will amend the initial law, right? And then there are repealing statutes. I have shown you the repealing statutes in my previous class. So you must have seen a repealing statute is one which terminates an earlier statute and may be done in the express or explicit language of the statute. For example, Competition Act repealed the MRTP Act. So these are repealing statutes. And you have seen there is a specific norm to interpret the repealing provisions under the General Clauses Act. So the repealing statutes are meant for repealing the provisions. Now, let me see. There are some, I think, queries on the chat box. Give me a second. Yeah. Codifying statutes. Anubhav, codifying statutes basically is a statute which codifies the customary laws. Like, for example, there may be laws which are not written or not in the statute, but by way of a practice, we do it. Like, for example, initially, the Hindu Marriage Act was not there. We were governed by Saptapadi and all those particular things was by way of a practice. Later on, they thought that it need to be codified. And then that is how they came up with Hindu Marriage Act. This was codification of the law. So if you see, Indian Penal Code was also not there. First Law Commission during the Britishers came up with this legislation, now which we have changed to Bharatiya Nyaya Sanhita, right? So this is called codification. Okay. Yeah. Difference between codifying statutes. Codifying statutes codifies the customary laws like Hindu Marriage Act and all. And consolidating statutes basically consolidates all the legislation. Generally, you will see consolidating statutes consolidates many legislation. For example, if you will see Contract Act used to consolidate many things because previously there was no Consumer Protection Act. There was no specific Relief Act. There was no Sales of Goods Act. All these provisions were in the Contract Act itself. So later on, these were all bifurcated and new legislations came up. So these were all consolidating statutes. So you are trying to consolidate many things in one statute is called consolidating statutes, right? Okay, now let me move further and talk about the provisions, and then I will take more questions during the break. So this is the classification of interpretation. Okay. Sure. So in your book, it is written like this. There are interpretation is divided into two parts, legal and doctrinal. And if you refer to other books on interpretation, like, for example, I refer to this GP Singh. You can see this is such a thick book. And this is a very, very thick book. And this book is basically on interpretation. So lawyers use them. You don't have to go through this particular book. This actually is summary of several hundreds decisions on each of these points. And while lawyer argue, they will find some case law which can support them. And that is what they will bring before the court and to make the argument. Here, general classification of interpretation from your point of view, you have to have a look at it. One is called legal and the other one is called doctrinal. Fitzgerald interpretation says there are two kinds, literal and functional. I will talk about each of them one by one. When you talk about legal interpretation basically is, interpretation is having two basic, ideas. There are two basic types, or you can say. And there is doctrinal, which is again two basic types, grammatical and logical. And the other one is authentic and usual. These are the two types of interpretation which has been talked about. Now, what the judge will be utilizing, which method or which type, will depend on the facts and circumstances of the situation. So, when the judge wants to actually find what the legal sense of that term is, or what is the law which needs to bind the the facts of the case, it will be referred to as legal. So in general parlance, you can say it is basically the strict interpretation, or you can say someone who sticks to the letter of law. And when you talk about doctrinal, this is a situation where the judge will be going into the purpose of the law and they will try to discover the real and true meaning of the statutes. That will be referred to as doctrinal, or it can also be referred to as functional, right? That is why Fitzgerald says literal and functional. So when we say legal or literal, that means you go by the letters of the law. So you will not go this way or that. There is no functional interpretation. It may appear to you that there is an injustice happening, but they will say that no, this is the literal interpretation of the law and this is how we interpret. Second is a situation where the judges will go into the depth of the matter and they will try to see that what was the objective of this law, why this law came up, what was the idea behind it, and they will try to see into that. And when they are discovering that particular purpose, it will be referred to as doctrinal or functional in nature. I hope this difference is clear to you. Now, legal interpretation is further subdivided into authentic and usual. And it is authentic when rule of interpretation is derived from the legislator himself. And it is usual when it comes from some other source, such as customs or case laws. Thus, when Justinian ordered that all the difficulties arising out of his legislation should be referred to him for decision, he was providing for authentic interpretation, and so also was Prussian Code. These are examples where you have to go back to the legislator for understanding what they wanted to say. Whereas when you go through the, when rule of interpretation is derived from some other source, like for example, customs or case laws, then that will be referred to as usual, right? In case of doctrinal, interpretation may again be divided into two categories. That is grammatical, when the court applies only the ordinary rules of a speech, and it will be referred to as logical, when the court applies, when the court goes beyond the words and try to discover the intention of the statute from some other way. Like, for example, I'll give you one example. Like when you are going to read shall as may and may as shall, it will be logical, right? So you are trying to draw a logic. When you go by grammatical, then you will not interpret shall as may or may as shall. Again, what is the bottom line? Bottom line is that context is the king. In interpretation, you have to see the context in which the law is there. So courts will most of the times look into the context in which the law has been framed, and they will try to interpret the provision accordingly. I will give you multiple examples today, and probably you will be able to understand it better. So this is what is the difference. So again, to repeat, there are two basic types of interpretation. One is legal, the other one is doctrinal. In case of legal, either it can be authentic or it can be usual, or in case of doctrinal, either it can be grammatical or it can be logical. So if you see, legal means strict interpretation, and in legal, authentic is further more strict interpretation. Okay, a bit of a leeway can be given in usual, whereas in doctrinal, grammatical is strict and logical is a bit of a, you are trying to bring the purpose of the legislation, trying to interpret it for the benefit of the person concerned. Now, let us move further and talk about the terms interpretation and construction. So most of the time, you will find that there is a term used, interpretation, and many a times you will find the term construction. And there is a difference between these two terms, interpretation and construction. So Justice G.P. Singh has authored a book on interpretation. And if you want to read more on interpretation, you should refer to Justice G.P. Singh if you really want to read it. Moving ahead, when we talk about interpretation, interpretation comes from the Latin word interpretati. So interpretari basically means to explain, to expound, understand, or to translate. So interpretation is basically a process of explaining, expounding, and translating any text or anything in written form, right? So this basically involves an act of discovering the true meaning of the language which has been used in the statute. So you are trying to find out what is written in the statute, what it wants to say, how it has to be interpreted, right? So this is what has been discussed here. Now, if you will see, Salmond is a jurist, okay? And he has defined interpretation in the process by which the court seeks to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed, right? So interpretation basically is nothing but a process by which the court seeks to ascertain the meaning of the legislature through the medium of authoritative form in which it is expressed. I told you in my previous class in the General Clauses Act that whose duty is of interpretation? It is the court's duty of interpretation. Who is interpreting? It is the court's duty to interpret. No one else can interpret. It is the only court which will be interpreting it, right? Now, if I move forward, I think some of you have raised your hand. Probably we will ask the questions. You can take up your questions during the break, right? So let me move ahead. You can note down your questions and you can ask them during the break. I will ask the technical person to open your audio and then you can ask me the questions. Okay. Now, let me move further and talk about another definition which has been given by Cooley. And as explained by Cooley, interpretation differs from construction in that the former is the art of finding out the true sense of any form of words, that is, sense which their author intended to convey, and of enabling others to derive from the same idea. That is interpretation. And construction, on the other hand, is drawing of conclusion respecting subjects that lie beyond the direct expression of the text from elements known from the letter of law. So it is basically, when you say interpretation, interpretation is reading what law has provided. Whereas construction is a situation where you are trying to go beyond the expression of the words. You are going into the intention, you are trying to read between the lines and bring something new out of it, will be referred to as construction, right? So I can give you one example. Like, for example, we are having basic feature of the Constitution. There is nothing called basic feature of the Constitution written there in the Constitution of India. However, you will see by way of a construction, the Supreme Court has interpreted the Constitution to bring out a philosophy that is called philosophy, or you can say a reality that is called basic feature of the Constitution. Though there is no definition of basic feature of the Constitution, but it is something which cannot be repealed or which cannot be taken away from the constitution, is called basic feature of the constitution, laid down in Keshavananda Bharti case, right? So this is how the interpretation and construction differs. However, in India, you will see these two terms are referred to as common. So they will find that most of the times people will be using interpretation. They will be also using construction, and both these terms they can use together. So there is no distinction as such between them. However, from a juristic point of view, you will see that there is a distinction between interpretation and construction. Now, I will take you through the 4 basic principles of interpretation of statutes. In all kinds of interpretation, you will be utilizing these 4 basic principles. So once you are clear with these 4 basic principles, you will be clear with interpretation. There is no challenge at all, right? So this is where you need to focus, right? So, so Anubhav, as I explained, there is no distinction between interpretation and construction as far as India is concerned. Okay, so it is interchangeably used. Okay. Salmond is a jurist. He has defined jurisprudence. Okay, so you don't have to remember his name. Probably they will not ask you this question you will have a technical question probably, or based on interpretation. But here, try to understand the basic principles. There are 4 basic principles. Okay, the first is intention of the legislature. So you need to be clear about intention of the legislature, that what is the intention of the legislature. You are able to see this picture. This is a picture from Lok Sabha. So whenever a law is made, they make their intention clear. What is this intention? Where do you get this intention? This intention you will get in the statement and objects or reasons of the law. So whenever there is a legislation which is presented before the parliament for passage, there is a reason given why this law is being brought up. They give you the reason. The minister will tell that yes, this law is brought because of this 4 reasons, 5 reasons. Okay, and there will be a debate, and after that the law is passed. So intention of the legislature is very important. For example, if you want to see what is the intention of the constitution makers, where do you go? You go to the Constitution Assembly debate. Constituent Assembly debates give you the framework for understanding what was the intention of the legislature or the Constituent Assembly when they framed the Constitution. This is the first one. Second is, statute must be read as a whole in the context. This is very important, that you have to read the things in the context. You cannot interpret a term out of the context. And that is why it is important, and it has been said that whenever you are doing the interpretation, you have to do the interpretation within that framework of the law. You cannot import something from another law and utilize to interpret in this law. Okay. So this is a very important part, that statute must be read as a whole in the context. Third point which is there, it is the basic norm, and it is called golden rule, that if meaning is plain, effect must be given to it irrespective of the consequences. So it is not the court's duty to look at the consequences. If the meaning is plain, effect must be given to it irrespective of the consequences. I'll give you an example. So example is, right now in Delhi, you are able to see that there is a, fuel has been denied to the vehicles which are beyond 10 years and 15 years, right? So what kind of a law has been applied? This particular principle has been applied very, very simply. If the meaning is plain, effect must be given to it irrespective of the consequences. Now, people may be saying that my vehicle is good, or I am suffering so much of a loss, or this is happening, or that is happening. But if law is there and it is plain and there is no confusion there, you cannot interpret it any other way. Now, what happens if this thing goes to the court? Court will interpret the law. Yes, the law has been provided like this within this jurisdiction. This has to go. Then they will say that it has to be interpreted like that, right? So you have to see that interpretation, if meaning is plain, effect must be given to it irrespective of the consequences. Now, you may have questions that what happens to the law then if it is unjust or something? Then in that situation, you have to go to the legislature, or the voters have to raise the point, and that is what is happening right now. So they are trying to look into that situation. Now, statute to be constituted to make it effective and workable. So many a times it will happen that there are conflicting provisions in a statute, or say, for example, there will be something which, if you read it literally, it may not be implemented. Then in that situation, courts will try to make it workable. Okay. If it is completely unworkable, then they will say that, okay, fine, this is not unworkable. New law has to be passed, or they will struck down that provision. But if there is a scope of interpreting it and making it workable, they will try to make it workable. These are the four basic principles of interpretation of statutes. Throughout all the slides which we are going to see now, you will be going through these provisions. These are very, very important provisions. Okay, that is intention of the legislature. You have, while interpreting a provision, you need to go to the intention of the legislature. Second, statute must be read as a whole in its context. Third, if meaning is plain, effect must be given to it irrespective of the consequences. And the fourth one, statute to be construed to make it effective and workable. Right? Now, let us move further and talk about a very interesting scenario, that in law, everything is not black and white. Okay. You cannot have everything black and white in law. There is always a twilight zone. And that is where you require interpretation or construction. If it would have been black and white, it would have been very easy. Everybody would have been able to interpret the law. There was no requirement of judges. Nowadays, coming up of the artificial intelligence, you could have just fed this particular thing, logic or things into the system, and they would have done it. Okay. There was no need for a lawyer or for a judge. However, there is a twilight zone, and I can give you this example with definition of day. Okay. So you will see there are a number of legislation in which day is defined. Okay. And you all know day and night. So when will be the day, when will be the night will depend on sunset and sunrise, right? And there are different definition of sunset and sunrise as per the civil, nautical, and astronomical systems. Okay. So if you will see, in case of astronomical systems, the night is lesser, day is more. In case of nautical systems, again, a bit more. So you can see there's a difference of 18 degree, 12 degree, and 6 degrees. So let us not go into the, geology part of it, but just try to understand that it is not day and night is not very, very distinct. So there will be a period which will be called Godhuli, or in the morning you will be having a period where there will be, in the evening you will be having a period of twilight, something like that. This period will be referred to as a zone of interpretation. You will classify that as day or night, you don't know, right? So if you will see, in India, women cannot be arrested after sunset or before sunrise unless there are exceptional circumstances. So this is specifically stated in section 46(4) of the Criminal Procedure Code. Now, what do you mean by day and what do you mean by night? Whether it will be 6 p.m. or whether it will be 7 p.m. In winters, you will see night comes around 8 p.m. But whether you will consider it as night, probably not. You have to go to the definition of night, which says after sunset. So you have to see the timing of sunset or the day on that particular day. What was the time of the sunset? So this is quite an interesting, point. And in case of Supreme Court, in the case of Sheila Barse versus State of Maharashtra, laid down the specific guidelines for arrest of women, and they said specifically that nobody should be arrested, no woman should be arrested after sunset and before sunrise. So this is unless there is a compelling reason for which there has to be a specific warrant and etc. Okay, now if we if we move further, we are going to the basic principles of legislature. Okay, so this is basically intention of the legislature. So what is intention of the legislature? The principle of intention of the legislature is central to the statutory interpretation, and it reflects the judiciary's role in understanding and implementing laws in the way the legislature intended. So idea is that while you are reading the legislature, you go back to the intention with which this particular law has been framed. And for you people, for example, if we will, try to understand, many a times you will see there is an exemption given of a particular product, particularly in case of MSMEs or in case of farmers, or there are exemptions which are given in case of women. All these exemptions which has been given in either in taxation or in corporation provisions, like say for example for startups, there is an exemption which is given. Now here, if you have to interpret these provisions and there is a confusion somewhere, you go back to the intention of the legislature and see what is the intention of the legislature, why intention came up, why this legislature came up with this provision. And when you go to the intention of the legislature, you understand the intention of the legislature, you will be able to interpret the provision properly, right? Like for example, in case of MSME, you would have seen there is a strict provision relating to the payment of MSME dues. So if you are not making payment of MSME dues, there are severe provisions. And there are declarations also. Probably you people may be aware in your accounts and all, you must have read about it. So why that provision is there? If someone has to interpret it, you will come to know that MSMEs are small companies and they need to be supported, and probably their payment, if they are not given by bigger players, then they cannot fight bigger players. And hence they need protection, and that is why there is a provision which mandates that within particular days payment has to be made, and there should not be any confusion around. So it is a very important provision, which important understanding, intention of the legislature has to be read from there. So it is founded on the premise that every law enacted by the legislature has a purpose, and interpreting the statute in alignment with that purpose is essential for justice and effective governance. The intention of legislature basically refers to the objective or purpose the legislative body sought to achieve when enacting particular statute. It is guiding principle for interpreting statutes to ensure that application aligns with legislative whims, right? So the duty of judicature is to act upon the true intention of the legislature, the mens or centennia legis. This is what has been held in one of the cases, Narayana Swamy versus Panir Selvam, as well as Institute of Chartered Account of India versus PricewaterhouseCoopers. So these are the cases in which the court held that you have to find out the legislature what they meant, or what is the centennia legis. This is a statement which was given by Denning, Lord Justice, and it is quite a very, very interesting statement. I would request you people to, if you can read. So what Lord Denning is saying? Lord Denning is saying it is not with human powers to foresee the manifold set of facts which may arise, and that even if it were, it is not possible to provide for them in terms free from all ambiguity. English language is not an instrument of mathematical precision, right? So you may have the term which may have different meanings, and our literature would be much poorer if it were. So literature is meant to have richness, but it is not having the precision, right? This is where the draftsmen of Act of Parliament have often been unfairly criticized. A judge believing himself to be fettered by the supposed rule that he must look to the language and nothing else, laments the draftsmen have not provided for this or that, or have been guilty of some or other ambiguity. It would certainly save the judges trouble if Acts of Parliament were drafted with divine prescience and perfect clarity. In the absence of it, when a defect appears, a judge cannot simply fold his hand and blame the draftsman. He must seek to work on the constructive task of finding the intention of the Parliament, and he must do this not only from the language of the statute, but also from a consideration of the social conditions which gave rise to it and to the mischief which it was passed to remedy. And then he must supplement the writing word so as to give force and life to the intention of the legislature. So you can see how profound the statement is. It is basically trying to give you all context why interpretation by courts are necessary. If it would have been that simpler, there was no need for these particular books and laws and interpretation, right? There was a need for this interpretation because in each of the situation, facts will differ and you would have to go to the facts of the situation, to the context to understand the legislation. What does it mean, right? So it is very important for us, all of us to understand for which purpose the law came, what was the mischief it was trying to remove. All these dimensions needs to be understood very, very clear. Is it clear till this point? Any questions you have? You can put the question in the chat box. I can see some of you are saying it is too technical. Yes, I understand it is technical. There is no room for it. A bit of interpretation is a very difficult subject. But for you people, you try to seek in the information. For you, there will be no difficult questions. Yes, this particular topic in the module Nidhi is you will find towards the end. Okay. So I'm giving you the introduction part of it in the module. There are certain things which you will not find in the module. You have to learn it from here because then you will be able to understand the module better. Now, in one case, Aaron Solomon versus Solomon, the House of Lords observed the intention of legislature is a slippery phase. What the legislature intended can be legitimately ascertained from that which it has chosen to write, either express words or reasonable and necessary implication. The construction which furthers the purpose or object of an enactment is described as purposive construction. Okay. And a purposive construction of an enactment is one which gives effect to legislative purpose by way of following the literal meaning of the enactment, where the meaning is in accordance with the legislative purpose, or applying a strained meaning where literal meaning is not in accordance with the legislative purpose. So this has been, discussed in this case. And it is, you can see there are two things which it is talking about. Okay. The first thing it is talking about is you have to most of the times refer to the literal meaning. What has been written, you read them and try to understand what has been written there. If literal meaning is not making sense, then there is a labor you have to do to find out exactly what the meaning or what was the purpose of the legislature in making the provision. Now, this is what is referred to as purposive interpretation or purposive construction. I want to give you an example. Okay. So you all are aware about demonetization case. You must be aware about demonetization case. This is not there in your syllabus, but you must be aware about it. What was the question there? The question in that particular situation was that central government initiated the demonetization process on its own and it passed it. An allegation was that it did not consult the RBI, which was found untrue. It consulted the RBI, but the argument which was made before the court of law or Supreme Court was that rather than central government initiating the process, it should have been the RBI which should have initiated the process, and then this demonetization thing should have been happened. Now, if you see the majority decision, they have applied the purposive interpretation. In para 128 of the case, that is Vivek Narayan Sharma versus Union of India, the court applied the purposive interpretation. And it clarified that demonetization under section 26(2) is a joint exercise. It is not a stepwise exercise where RBI has to always initiate. Even if the central government has initiated and it has consulted RBI and there is a joint, agreement on this aspect, then there is no problem. So that is what the court said. However, in this dissenting opinion, Justice Nagaratna said that no, this process needs to be followed. And if there is a statute mentioned, so she went ahead with a more literal interpretation. But majority of the judges said that there should be purposive interpretation. So this is where you can see there are different judges also giving different judgments and different interpretation, but it is the majority which prevails, and that is how this gets interpreted. So I gave you one example of purposive interpretation over literal interpretation. So I hope this makes the things clear for you. Now there is another jurist called Craze, and he has written a book on legislation, and he has given 5 steps of interpretation, so which needs to be followed. So when legislation has to be understood, first thing which you will do is read the provision. I always suggest my students, whenever you have to interpret a law, you need to read the bare provisions. Once you read it, and whatever plain meaning you can get through that is the meaning of that provision. If you are not able to understand it, then you should go to the next step, right? So when the plain meaning is in doubt, the court will start the process of construction by attempting to discover from the provisions enacted the purpose of the legislation. And you will go to understand the purpose of the legislation. Where you will find the purpose? Purpose you will find by way of both the things, either internal to the statute or external to the statute. And that is where external aids and internal aids come. I will touch upon that in a while. Third, where a particular reading would advance the purpose identified and would do no violence to the plain meaning of the provisions enacted, the courts will be prepared to adopt that reading. So try to understand here, there are 2 things which Craze is saying. One, it is saying that interpretation which is promoting the purpose with which the law has been enacted. And second, it is doing no violence to the written words. So you cannot cut the written words or you cannot ignore the written words of the legislature. You have to, if there is a very express plain thing written, you cannot change it. You cannot interpret it otherwise, right? So you need to interpret it accordingly. However, if there is no violence to that, then you can interpret it to promote the purpose of the legislation. Fourth, where a particular reading would advance the purpose identified but would strain the plain meaning of the provisions enacted, the result will depend on the context and in particular on a balance of clarity of the purpose identified and the degree of strain on the language. Fifth, where the courts concluded that the underlying purpose of legislation is insufficiently plain or cannot be advanced without an unacceptable degree of violence to the language used, they will be obligated, however, regretfully, in the circumstances of the particular case, to leave the legislature and task of extending or modifying the legislation. So most of the times you will see courts will say that, okay, fine, we are not dealing with this. This is in the ball is in the court of the legislature. Like, for example, you same-sex marriage. That was a case where court said that, no, we are not going to interpret this particular thing further because the legislation is not that clear. Let the thing go into the legislature's court, or legislature should clarify this. Many a times courts would say that, and this is the 5th stage of interpretation. So this is how the legislation proceeds. So these are the 5 important steps by which you find out how the interpretation happens. Now, let us move ahead with the second basic principles. Okay. So there is again question coming up where it is in the module. You will find this in the module towards the end in basic interpretation of statutes. Now, basic principles: a statute must be read as a whole in its context. So whenever you are reading a statute, you cannot read a statute in parts. You have to read the statute as a whole. So it is very, very important to read the statute as a whole. So let us see what this means. Saying when the question arises as to the meaning of certain provisions in a statute, it is not only legitimate but proper to read that provision in its context. The context means the statute as a whole, the previous statute of law, other statutes in pari materia. In pari materia means the similar kind of laws, the general scope of statute and mischief that it was intended to remedy. This is what was held in Union of India versus Elphinstone Spinning. Lord Davey said, every clause of a statute should be construed with reference to the context and other clauses of the Act, so as far as possible to make a consistent enactment of the whole statute or series of statutes relating to the subject matter. It is a spoken or construction ex viceribus actus. To ascertain the meaning of a clause in a statute, the court must look at the whole statute at which, which you will find previously or afterwards. You need to look at them together. You need to look at them all together to understand what the law is trying to say. So, if you see in Tulsamma's case, it was said it is an elementary rule of construction that no provision of a statute should be construed in isolation, but it should be construed with reference to the context and in the light of the other provisions of the statute. In one of the cases, Justice Sinha from the Supreme Court, who was CJI also, he said the court must ascertain the intention of the legislature by directing its attention not merely to the clauses to be construed, but to the entire statute. It must compare the clauses with the other parts of the law and the setting in which the clause is to be interpreted occurs. It is also apt to take note of few decisions of the apex court with regard to interpretation of statutes. This is what he said in State of West Bengal versus Union of India. But I have recently interacted with Justice Maheshwari, and he says that before going into the any decisions or judgments, you have to go through the bare provisions. Nothing can guide you better than reading the bare provisions yourself. So always you should read the bare provisions. Okay, and bare provisions means the original text. So this is the another principle. Third principle, we will move to the principle, third principle, and we will try to understand also the role of judges. So while examining a particular statute for finding out the legislative intent, it is the attitude of judges in arriving at a solution by striking a balance between the letter and spirit of the statute without acknowledging that they have in any way supplement the statute would be the proper criteria. So what is the duty of judges? Duty of judges is to expound the law and not legislate. So they cannot come up with a law. It is the fundamental rule. There is no doubt a marginal area in which the courts basically mold or creatively interpret legislation, and they are thus finishers, refiners, and polishers of legislation. This is what has been said by Supreme Court in State of Haryana versus Sampurna Singh. Where there is a requirement, they will make a fine tuning of the law, or they will refine it or polish it. This is what is the role of judges. But by no stretch of imagination, a judge is entitled to add something more than what is there in the statute by way of a supposed intention of the legislature. It is therefore a cardinal principle of construction of statute that the true or legal meaning of enactment is derived by considering the meaning of the words used in the enactment in the light of any discernible purpose or object which comprehends the mischief and its remedy to which the enactment is directed. Applying the aforesaid principle, we really fail to understand how the learned judges of the Bombay High Court could come to a conclusion that the mismanagement must necessarily mean an element of fraud or dishonesty. Courts are not entitled to usurp legislative function under the disguise of interpretation, and they must avoid the danger of determining the meaning of a provision based on their own preconceived notion of ideological structure or scheme into which the provision is to be interpreted or fitted. This is what has been held in DuPont Steels versus Sears in 1980. Caution is all more necessary in dealing with the legislation enacted to give effect to policies that are subject to bitter public and parliamentary controversy. For in controversial matters, there is a room for differences of opinion as to what is expedient, what is just, and what is morally justifiable. It is Parliament's opinion in this matter that is paramount. So there is always a conflict, many a times you will see, between the judicial interpretation and legislature's intention. And the question is to what extent the judges can interpret it and interpret it differently. So in this case, Bombay High Court interpretation was not accepted, where mismanagement means fraud or dishonesty. These are the two different things. Mismanagement, operation and mismanagement, you must have heard. That does not mean fraud. Okay, corporate fraud is defined separately. It cannot mean mismanagement. So this is what is the role of judges. As you are able to see, role of judges are clearly laid down. The third principle is statute should be construed to make it effective and workable. So in one of the cases, the question arose for determination. After this slide, we will take a break. So the question that arose for determination in this appeal was whether section 28(1) read with section 18A subclause 9 of the Act is competent to income tax authority to impose a penalty on a person who has failed to comply with so and so section of the Act. So if you will see, the legislature enacted this with a very object of bringing the failure to send estimates under so and so within operation of section 28. It signally failed to achieve its objective. The construction which leads to such result must, if that possible, be avoided on the principle expressed in the maxim so and so. It is better for a thing to have effect than to make it void. The only alternative construction offered to us would lead to this result, that the plain intention of the legislature has entirely failed by reason of a slight inexactitude in the language of the section. If we were to adopt this construction, we would be construing the Act in order to defeat its objective rather than with a view to carry its object into effect. So you will see in this particular case, the court was of a view that if we take this interpretation, the statute will be made useless. The objective of the law will not be attained. So hence, to be workable and interpretation, therefore, the court should be secure that object unless crucial omission or clear directions make that end untenable. So here, idea is most of the times, the judges will be making a construction in a way that the provisions becomes workable and effective without doing injustice. Okay. So this is how the basic principle, another basic principle talks about. Lastly, if meaning is plain, effect must be given to it irrespective of the consequences. This is a well-settled principle. And I have given you the example also by way of this recent Delhi, fuel case. The intention of legislature has to be provided, irrespective of the case, that what kind of a harm it causes. So necessity of interpretation of would arise only when there is a ambiguity. If the provisions are plain, there is no need for doing it otherwise. So the rule of construction of acts of parliament is that they should be construed according to the intent of the parliament which has passed it. The words of the statute are of themselves precise and unambiguous. Then no more can be necessary to expound those words in their natural, ordinary sense. The words themselves do, in such case, best declare the intention of the legislature. And we have, for this, there is a Rahul Gandhi case. I think I will break here, and you people can reflect upon the Rahul Gandhi defamation case, and we will have a discussion after the break. So we take a 15 minutes break here. Any questions you have, you can ask me right now before we take the break, if you have any questions till this point. Yes, Anubhav, it is a bit technical subject, but if you read it at least 1 or 2 times, it will become easier for you. There are some terms which are a bit technical. I can Understand that, but you should not get disheartened with this. Okay. It will come by way of a practice. Legal language comes by way of a practice. Once you start reading it, it will come to you as well. And you being chartered accountants, you have to read the law every time. Every year you have to read the Finance Act, which will come. New legislations and new provisions. You need to understand what the provision says. Okay. Okay, then. So if there are no questions, we will take a break, 15 minutes break, and we assemble at 7:30 now. Okay. See you at 7:30. You can take a break. Okay. Then Asta has questions with reference to the module. Okay. I have to open the module. Let me see if I have right now ready-made. Okay, so let me take you to this Rahul Gandhi's case first, and then we will see because I have to open the book. So when we talk about this Rahul Gandhi case, it is basically in the context of, if you will see, this is in the context of plain meaning must be given the effect. So this case, you must be aware, there was a case which was filed by one of the MLAs, BJP MLA, Mr. Purnesh Modi, okay, about defamation. So this was election rally in which Mr. Rahul Gandhi made a statement, and that was taken into consideration as a defamation, and he filed a case before the court. And if you will see this case, the court, magistrates court, actually found him guilty, and he gave a conviction. And on the basis of this conviction, this was for 2 years, he was disqualified from the parliament. The Lok Sabha Secretariat issued a notification informing various offices, Election Commission of India, about his disqualification. So if you will see, there was a very literal interpretation of this disqualification, because under Section 8 of the Representation of People Act and Article 102 of the Constitution, the disqualification of members is on conviction of certain offences which are punished with imprisonment of 2 years or more years. So since in this case he was punished for 2 years, then automatically there was a disqualification which happened in this case. So you can see this is how it was interpreted. Can it would have been interpreted in a liberal way, or they would have said, okay, fine, even if it provides for 2 years, okay, it is only say 2 years, so the exemption can be given. Likely not, because the law has to be strictly interpreted, and in this there was a interpretation accordingly done in this case. Okay, so this is how you need to have a look at these different cases. So when you read these cases, automatically you will see in some of the cases there is an interpretation clause which has been utilized by the court, and they have dealt with the sections, they dealt with the clauses accordingly. In another case, if you will see this MV Joshi versus MU Shimpi and others, this was a case in which the Mr. MV Joshi was a butter dealer, okay? And he was convicted for selling butter that was below the prescribed standards. So the question was, the core issue revolved around whether butter prepared from curd falls within the definition of the butter as stipulated by the relevant rules or not, and whether selling such butter constitutes an offense under the Act. This was the question. So the fundamental principle of interpretation in this case, that the primary test is language employed in the Act, and when the words are clear and plain, the court is bound to accept and express the intention of the legislature. So in this case, what happened is food inspector seized butter from MV Joshi's shop, which upon analysis was found to contain 18.32% foreign fat, 19.5.7% moisture, and 64.67% milk fat, thereby failing to meet the prescribed standards under Rule so and so of prevention of food adulteration rules. The judicial magistrate initially acquitted Joshi, arguing that the butter prepared from curd did not fit the legal definition of butter. However, the High Court overturned this acquittal, asserting that butter prepared from curd is indeed covered by the definition, and that setting butter below the prescribed standard qualifies as selling adulterated food. So the Supreme Court upheld the High Court's decision, adjusting the sentence from rigorous imprisonment to a fine, thereby reinforcing the interpretation that butter made from curd is subject to same standards as butter made directly from the milk or cream. So you can see how the interpretation is done. So the party has tried to make an interpretation that no, this particular butter will not qualify as butter as produced by another processing. But court said that no, if you are talking about the butter and its healthiness, then it has to be done as prescribed. So this is how a strict interpretation in case of food adulteration laws has been done. Now there are different rules of interpretation. If you will see in your module, there are two different kinds of rules of interpretation mentioned. The first is primary rules of interpretation, and the second one is secondary rule of interpretation. In case of primary rules of interpretation, you will find there have been 7 rules talked about: rule of literal construction, rule of reasonable construction, rule of harmonious construction, rule of Haydn's case or mischief rule, rule of beneficial construction, rule of exceptional construction, and rule of ejusdem generis. Another, in secondary rules, there are doctrine nocitur e soci and doctrine of contemporanea expositio. Okay, so now we will talk about each of these rules of interpretation one by one. So the first principle or a first rule of interpretation is rule of literal construction. As the name says, the focus is on the word literal. Literal means what? Literals means written. Literal rule, also known as the plain meaning rule, is basically a type of statutory construction for interpretation, which dictates that statutes are to be interpreted using the ordinary meaning of the language of the statute, unless a statute explicitly defines some of its terms otherwise. So you will see a plain meaning, you will see a natural meaning of that particular word, and that is what is literal rule. Okay, and in other words, the law is to be read word for word and should not divert from its true meaning. It is the mechanism that underlines textualism and to a certain extent originalism. So you see whatever has been written in the text, you read the text and understand what it says. You don't read between the lines or go into the depth of it, what meaning it would have been given. Whatever plain meaning it is giving, you go ahead with that rule of literal construction. The Latin maxim absolute Cha senetia expositor non indigent literally means an absolute sentence or preposition needs no expositor. In other words, plain words require no explanation. This is what is the rule of literal construction. Thus, it is primary duty of the court to interpret the words used in legislation according to their ordinary grammatical meaning in the absence of any ambiguity or doubt. So, in principle of statutory interpretation, also this has been said. The intention of the legislature is primarily to be gathered from the language used, which means that attention should be paid to what has been said as also to what has not been said. As a consequence, a construction which requires for its support addition or substitution of words, which results in rejection of words as meaningless, has to be avoided. So you cannot reject a word for doing a particular construction in a written statute. So the language of the statute should be read as it is. This is what it has been said. Let us take some examples. So avoidance or adding or substitution of words is not permitted. So in the case of British India General Insurance versus Captain Itbar Singh, question was, what is the scope of defenses available to the insurers under section 96(2) of the Motor Vehicles Act? The court held that insurers cannot challenge the quantum of compensation awarded unless they prove one of the grounds specified in section 96(2) of the Motor Vehicles Act. No additional ground may be added by inserting the word also after the words on any of the following grounds. So if you will see here, this is the section which was subject to interpretation. No sum shall be payable by insurer so and so, so and so. And towards the end, the underlined part you are able to see on any of the following grounds, namely, that means it is specifically providing X number of grounds. You cannot include another ground by saying that, okay, fine, it is saying it may another grounds of similar nature can be included here. You cannot do that because the statute has not provided it. So the court reinforced the doctrine that no word should be added or omitted in interpreting statutory text unless absolutely necessary to avoid absurdity or inconsistency. So in this provision, there was no confusion to add also. So if you add also, that means you can include anything under this legislation, which basically legislature did not want. So legislature wanted that only those grounds insurer can challenge, but not on any other ground. So this is one example of interpreting the statute as it is. You cannot avoid or add any words to it. There is another thing which is called causus omissus. So many a times while interpreting the provisions, you may find that there is some vacuum. Can we add some word to make sense of that particular word? So here, in the case of Gladstone versus Bower, a foundational decision in contract law explores the principle of equitable estoppel and the requirement for the clarity of contractual terms. It emphasizes the importance of interpreting contractual terms based on their plain meaning without assuming additions or substitution. So the court held that no words or obligations can be implied into a contract unless it is necessary to give business efficiency to the agreement. The principle applied was that the parties must abide strictly by the words of the contract unless those words lead to an absurdity or fail to achieve the clear intention of both the parties. The case underscores 2 points. One, literal rule of construction requires interpreting a statute or contract exactly as written. So you will be able to see here, I am also referring to interpretation or construction of a document, right? Contract is a document. Courts should not modify contracts by inserting or omitting terms except in circumstances where the omission makes the contract unworkable or leads to absurd outcomes. Here comes the infamous case of Rogers versus Alliant, in which the termination clause was challenged based on a comma. This was quite an interesting case. On a basis of a comma, the termination clause was challenged, and there was millions which was lost in this particular case. You people should search this case. This is a very interesting, and this is a homework for you people. Tomorrow I will ask you this case. Okay, that is the contract was lost or millions were lost because of a comma. There are two cases basically in this area, but let us see how many of you find it in tomorrow's class. Okay, we will begin the class with this. Another case was Bangalore Water Supply versus Sewage Board, Ajappa. Okay. And the case involved the interpretation of the term industry under the Industrial Disputes Act. And here the court extended the scope of the term industry by expanding while acknowledging the omission. Similar is the situation if you will see the Constitution's provision, Article 21. In Article 21, the provision goes like this: no person shall be deprived of the personal life and liberty, okay, except according to the procedure established by law. Now, here the court has interpreted this life and liberty to expand so many things, if you will see, right? So, here the court has tried to provide the unenumerated rights or additional rights to people by way of filling this causes omissus. I hope it makes sense to you. But in general situations, court will not add any sentences or words into the statute to give you benefit. But since it was a constitutional provision, the court has gone that way to provide the benefit. Now, let me avoid rejection of words. This is another important point. While doing the literal, you cannot just deliberately remove a word. Similarly, as you cannot deliberately include, you cannot remove any word. So in case of State of Bombay versus Ali Gulshan, the omitting portion unnecessary for our present purpose runs in these terms. It was written like this: and the state government may, by order in writing, requisition the premises of the purposes of the state or for public purpose, and may use or deal with the premises for any such purpose in such manner as may appear to be expedient. Okay. So this was a case in which the validity of the act was not questioned as unconstitutional or as beyond the scope of legislative competence of the state, as the premises were required for housing a member of a staff of the consulate. There can be no doubt that this was wanted for a public purpose. So it was basically held that this is public purpose. So any purpose can be classified as public purpose. And if it is a public purpose, then the house could have been acquired. This is what has been held in this particular case. Otherwise, the court should lean against a construction which would render the statute, without usage. So one has to see, you cannot just discard a word or a sentence from the statute for your convenience. This is what it is saying. There is another, jurist who has written a book on statutory interpretation, that is Cross. And he says the governing idea here is that if a statutory provision is intelligible in the context of ordinary language, it ought without more to be interpreted in accordance with the meaning an ordinary speaker of the language would ascribe to it as its obvious meaning, unless there is sufficient reason for a different interpretation. So, if you are making a different interpretation, if you are making a different interpretation of that particular word, you need to give sufficient reason. So judges will generally give that reason for differentiating from the normal course. Thus, an ordinary meaning or a grammatical meaning does not imply that judge attributes a meaning to the words of a statute independently of their context or for the purpose of the statute, but rather that he adopts a meaning which is appropriate in relation to the immediately obvious and unsearched context and purpose in and for which they are used. So by enabling citizens and their advisors to rely on ordinary meaning, unless notice is given to contrary, the legislature contributes to legal certainty. So this is a very important aspect, that why we are interpreting in a particular way, because you want to give a legal certainty. You cannot have interpretation as per your conveniences. कि आपने एक बार word को हटा दिया, एक बार जोड़ दिया, that is not possible. You have to give consistency to the interpretation, and there has to be a greater transparency in its own decision, both which are important and value of the democratic society. So in determining the meaning of any words or phrases in a statute, ask for the natural or ordinary meaning that the word or phrase in its context in a statute and follow the same, unless that meaning leads to some results which cannot reasonably be supposed to have been in legislative intent. Rules of construction are our servants and not masters, and a statutory provision cannot be assigned a meaning which it cannot reasonably bear. If more than one meaning are capable, you can choose one, but beyond that you must not go. This is what Lord Reed said. So this is about literal construction. So what do you get from the literal construction? That you will give the plain meaning to the words which are there in the statute. You will not add something or take away something from the rule, right? This is what is the rule of literal interpretation. Now comes the second one is rule of reasonable construction, or this is also referred to as golden rule of interpretation. So many a times situation arises that when you are doing a literal interpretation, you are not able to make any sense. Then you cannot, what was one of the principles? That you should try that the law should be interpreted in a way to make it workable, right? That is what was one of the principles. So to make it workable, you need to find some solution, right? And hence, to find that solution, this golden rule of interpretation comes into picture, which says rule of reasonable construction. So golden rule of interpretation is legal principle basically that allows the courts to modify the meaning of the law to avoid absurd outcomes. It's used when the literal meaning of law is clear, but leads to an unreasonable or unjust result. Okay. So the words of a statute must be construed so as to lead to a sensible meaning. When a grammatical interpretation leads to a manifest absurdity, then the courts shall interpret the statute so as to resolve the inconsistency and make the enactment a consistent whole. This principle is based on the rule that the words of a statute must be construed reasonably so as to give effect to the enactment rather than reduce it to a futility. Okay. The principle is contained in Latin maxim interpretatio fienda est ut res magis valet quem perit. You don't have to remember this maxim. It is just for your reference. In short, statutes should be construed grammatically. Okay. Let us take an example. So this is an interesting example. So you are able to see here. These are the two boxes. Okay. And let us try to see. So this is Alder versus George. So in this is an English public law case, and this exemplifies the application of golden rule. So here you will see this case involved interpretation of Section 3 of the Official Secrets Act of 1920. Okay. So according to the Act, it was an offense to obstruct Her Majesty forces in the vicinity of a prohibited place. Okay. The defendant entered an RAF station. So a prohibited place under the Act. So RAF station is a prohibited place. And so he argued, it was interesting. Okay. So the Act says in the vicinity of the prohibited place. It is not saying that in the prohibited place. Okay. So his argument was interesting. He was a good lawyer. He argued that the blue area, the light blue area, it is a vicinity. A is in RAF station. So he argued that he was not in the vicinity of the station as required by literal reading of the statute. The key issue was whether the defendant, by entering the RAF station, violated the terms of the Act given the literal interpretation in the vicinity. Okay. Interesting, no? So in the High Court, the defendant's conviction was upheld under the golden rule of statutory interpretation. The court applied the golden rule to avoid an absurd outcome and extended the meaning of the in the vicinity to include in or in the vicinity of. Right? So this is what is the application of interpretation of golden rule. I hope you understood this example. So Lord Parker in this case emphasized the potential absurdity in strictly adhering to the literal rule. He stated that it would be extraordinary and absurd if an indictable offense was created when obstruction occurred just outside the precincts of the station, but in the vicinity. On the other hand, no offense would be created if the obstruction occurred directly on the station itself. The judges used the golden rule, allowed for a more reasonable interpretation that aligned with the broader purpose of the statute. I hope you got this understanding clear. Then comes the third rule is the rule of harmonious construction. So the rule of harmonious construction is applied when there is a conflict between two provisions of the statute. It happens many a times that one provision is saying something, another provision is saying something. Then this rule aids that conflict and tries to make a balance or harmony between those provisions. So environmental regulations versus economic development. This comes many a times. Okay. So if one law protects the environment while another encourages economic development in the same area, the court can use harmonious construction to balance the two laws. So this happens most of the times. One of the important decision was this, if you remember, in Rajasthan or in Gujarat, the bustards case, where there was a bird and there was a challenge because they were planting a solar plant there, and it was said these migratory birds comes to that particular area. The beautiful decision by the Supreme Court in this, balancing the economic, environmental regulation and economic development. There are multiple cases around this. You can see Goa Foundation case. These are all cases in which this argument or this discussion has happened. So it is a basic rule of interpretation that if it is possible to avoid a conflict between two provisions or a proper construction thereof, then it is the duty of the court to so construe them and they are in harmony with each other. So a specific rule will override a general rule. This principle is usually expressed by the maxim generalia specialibus non derogant. This is very important. A special rule will override a general rule. So if there is a special rule will take precedence over a general rule. So I hope you understood this harmonious construction. We will talk about it more. So in Supreme Court, in the case of Commissioner of Income Tax versus Hindustan Bulk Carrier, laid down the following principle for harmonious construction. So it said, while interpreting the provisions, the courts need to avoid all circumstances of head-on clash between provisions. They must be construed harmoniously. Interpretation by the courts should be done in such a way that one provision does not defeat the another provision unless there seems to be no possible construction. Okay, give me a second. I'm connecting my charger. Yes. So any construction that renders one provision of the statute useless or dead letter should not be given effect to. Such construction is not a harmonious construction. So harmonious construction, you have to balance it. I can give you one more example. In Constitution of India, we have fundamental rights and we have directive principles of state policy. Now, these are the two different provisions. One is enforceable, another is non-enforceable. So in Minerva Will's case, the Supreme Court interpreted it in such a way that you have to harmoniously read directive principles into the fundamental rights also. And that is why some of the fundamental rights have been given the status of some of the directive principles have been given the status of the fundamental rights. Like, for example, right to education initially, which was later on included as Article 21A as the fundamental right. I hope that you got this. Similarly, in case of Kerala Education Bill, it was Supreme Court held that deciding the fundamental rights, the court must consider the directive principles and adopt the principle of harmonious construction. So two possibilities are given effect as much as possible by striking a balance. Now, let us move further. Now, when you are doing harmonious construction, you have to do it in a number of ways. So one is regarding to subject and object. So in case of UP Bhudhan Yagna, the context of the UP Bhudhan Yagna Act was that the Supreme Court emphasized that landless persons, I don't know whether you people know about this Bhudhan Yagna case. So at a point in time, there were zamindars and there were people who didn't had any bhumi, right, or any land. So it was decided under this particular law that some land which will be taken from the bigger zamindars will be distributed to landless persons. And they should be eligible for redistributed land, must meet specific criteria as defined in the Act. In this case, the court held that mere lack of formal land ownership was not enough. Landless people should also demonstrate an economic need of the land consistent with the welfare objectives of the Act. This is what is the statement and objects of that particular legislation. And accordingly, the law was interpreted. Now, in some cases, the statute may give a clear indication as to which provision is subservient or which overrides. Okay, subservient means subordinate to. This is done by using the term subject to, notwithstanding, and without prejudice. You must have, seen these particular words in your statutes, right? Many a time subject to is used, notwithstanding is used, and without prejudice is used. So the impact of the words subject to when used in a provision is that when the same subject matter is covered by that provision, and by another provision or enactment subject to which it operates, and this is a conflict between them, then the latter will prevail over the former. For example, Section 13(2) of the Companies Act 2013 says any change in the name of the company shall be subject to the provisions of subsection 2 and 3 of section 4 and shall not have effect except with the approval of the central government in writing. What do you mean by that? That there is a requirement that you have to take the central government approval, and it cannot be for against subsection 2 and 3 of section 4 of the Companies Act. So you can change the name of the company provided you meet the conditions under subsection 2 and 3. So it cannot be derogatory to that. Okay. Without prejudice, many a times words you will see is without prejudice. So when certain particular provisions follow general provisions, and when it is stated that the particular provisions are without prejudice to those general provisions, the particular provisions will not restrict or circumscribe the operation and generality of the preceding provisions in other words, the particular provisions shall operate in addition to and not in derogation of general provisions. You remember I gave you just now this particular maxim, a specific rule will override a general rule. So this is exception to this particular rule actually. Okay. So here you are able to see without prejudice. So if you say without prejudice, that means whatever you are saying, that is an exception. Okay. So if say, for example, I say without prejudice of me saying that you should not ask any questions, you are permitted to ask questions. Okay. So that means, what do you mean by that? That means you are permitted to ask questions because I have used the word without prejudice. So whatever I say is without prejudice, means that is not applicable basically. Notwithstanding or non-obstante clause. So many a times you will see that the statute begins with a non-obstante clause. That means notwithstanding anything contained. So if any law which begins with notwithstanding anything contained is called non-obstante clause. Unlike the subject to clause, the notwithstanding clause has the effect of making the provision prevail over others. So when this term is used, then the clauses will prevail over other provisions mentioned there. So wherever it is written, notwithstanding anything stated in this particular law, this will prevail. This is how it works, notwithstanding. Okay. These are some of the examples of clauses which can operate at 4 levels. Okay. So notwithstanding anything contained in another section or subsection of that statute. So you see section 42 subclause 1 of the Companies Act talks about this. This is how it is written. You are able to see here. Notwithstanding anything contained in subsection 9 of section 10, any private placement issue not made in compliance with the provision of so and so shall be deemed to be a public offer. And all the provisions of this Act and Securities Contract Regulation Act and Securities Exchange Board of India shall be applicable. Now your questions may be based around these. So you may have a situation and there will be 4 options. You need to see what will apply here. Okay. So please have a look at this particular provision. You people can have yourself, please have a look at it. Yeah. So notwithstanding anything contained in a statute, notwithstanding anything contained in specific section or subsection, and notwithstanding anything contained in any law for the timing in force. These are the different types of notwithstanding which can be utilized. So when you say notwithstanding anything contained in another section or subsection of the statute, you are referring to one section. When you are saying notwithstanding contained in a statute, that means you are referring to that statute. Notwithstanding anything contained in specific sections or subsections or all of the provisions contained in another statute, then you are referring to that. Notwithstanding anything contained in any other law for the timing in force, that means you are referring to all kinds of laws. This law will prevail over other laws. This is what you are trying to say. I will share this particular slide. Kindly go through this particular slide in detail. And if you have any further questions, you can ask me in tomorrow's, in day after class. Let me proceed further. This is another rule. And this rule is referred to as Hayden's rule, or you can say mischief rule. This case is interesting case, and this law came up with idea of curing a mischief. Okay, so this case involved leases, life estates, and statutes. So Ottery College granted a tenancy in a manner to where the father and where the son. Okay. So this tenancy established by copyhold was subject to the Lord's will and manors custom. The same parcel was later leased to Haydon for 80 years. Now, Parliament enacted the Suppression of Religious Houses Act in 1535 and dissolving religious colleges. However, the act protected grants made over a year before its enactment. The Court of Exchequer found that the grant to Wares protected but declared Haydon's lease void. Okay, so this is what was held in this case. Now, the Lord Coke described the process through which the court must interpret the legislation. So, for the sure and true interpretation of statutes in general, by they penal or beneficial, restrictive or enlarging of the common law, four things are to be discerned and considered. First, what was the common law before making of the act? Second, what was the mischief and defect for which the common law did not provide? Third, what remedy the Parliament had solved the result and pointed to cure the disease of the Commonwealth and the true reason for the remedy. These are the four questions which you ask whenever there is a application of mischief rule. And then the office of all the judges is always to make such construction and shall suppress the mischief and advance the remedy and to suppress subtle inventions and evasions for continuance of mischief and pro privato commodo and to add force and life to cure and remedy according to the true intent of the makers of the act pro bono publico. Right? So this is what was held in this particular case. Just a second. Yeah. So now here what happened in this case, Haydon's case. Now you people should find out. Okay. In this case, what court said. Whether this was held the Court of Exchequer found the grant of Wares protected but declared Haydon's lease void. So they found the lease of Haydon's void. Why they found it void? Because he had given that particular lease for saving himself from the Religious Houses Act. So it was not for the purpose of anything else, but they wanted to save themselves from the Religious Houses Act, and then it was not, that is why it was not permitted. Another example, application of this mischief rule is also well founded in construction of section 2D of the Price Competitions Act. The section defines price competition as any competition in which prizes are offered for the solution of any puzzle based upon a building up arrangement, combination or permutation of letters. Okay. Now, the issue was whether the act applies to competitions which involve substantial skill and are not in the nature of gambling. So, Supreme Court, after referring to previous state of law, to the mischief that continued under that law and to the resolutions of various states under Article 252(1), authorizing Parliament to pass the act, has stated as follows. Having regard to the history of legislation, the declared object thereof, and the wording of the statute, we are of the opinion that the competitions which are sought to be controlled and regulated by the act are only those competitions in which success do not depend upon any substantial degree or skill. Okay. In India, in Kanai Lal Pramadhi, the Honorable Supreme Court held that the observation made by the Chief Baron and Barons of Exchequer in Haydon's case have been so frequently cited with approval by the courts administering provisions of welfare enactments that they have now attained the status of classes example. So this is basically mischief rule. If you have to understand it, basic premise is that any legislation which has been enacted is enacted for the purpose of solving a problem. So you need, what this rule is saying, this rule is saying that you need to find out what was the law before the problem, what problem the new law sought to address. Third, whether the problem which was provided has been resolved or not, and what was the remedy which was provided by way of the new law. This is what exactly it mentions or it tries to tell. Okay. Like, for example, I can give you one example. Say, for example, in the Information Technology Act, there is a social media regulation rules which was notified. What is the objective? Objective is that what was the problem? Problem was that social media intermediaries were not accountable, and any grievance or problem, if someone wanted to raise, there was no forum. So this was the mischief. This mischief need to be cured, and that is why the rules came up which mandated that the bigger social media enterprises should be having reverse retrieval cell, and if the government tells them that they have to put down a particular post, they need to put down that particular post, and that was the mischief which they wanted to, cure. And the reason for that remedy was that there has to be some regulation of social media or OTT platform. So this is how you need to interpret it. I hope you understood the mischief rule. Okay. Then a critique. So mischief rule, there is in US, there is a critique, and it says that every time this mischief rule is not applicable, what I would do is I will leave this particular critique for your consumption and for your homework. Probably you should reflect upon it, and I will discuss this maybe in our next class, or if it is not required also. But if you are interested, I will be happy to discuss this in our next class. The another rule which is there is of beneficial construction. So this is strictly speaking not a rule, but a method of interpreting the provision. And this is basically what happens is in many of the situations, the court goes for a liberal interpretation. So beneficial construction will be given to a statute which brings into effect the improving the condition of certain classes of people who are underprivileged or who cannot be treated fairly in the past. So generally, any provisions which relates to the economic weaker section people, SC, STs, women, children, these are the things which will be, or maybe in case of workmen, in case of labor, in case of tenant, these are the things which are where there will be a bit of a beneficial construction which will be given to the people for whom the law has been brought up. For example, in Alembic chemical work versus workmen, the industrial tribunal awarded more number of paid leaves to the worker than what was mentioned in so and so act. And objective was that, okay, fine, you need to take care of the employee, etc., etc. Similarly, in Tolaram versus State of Bombay, the court observed it is well rules of construction of penal statutes that if two possible and reasonable constructions are possible, then whichever construction supports the accused, that will be taken into consideration. So you see, in criminal law, we say beyond reasonable doubt. Okay, so even if there is a small doubt in the proving of crime, you have to, release that person. Similarly, under Article 21, I gave you the reference, no person shall be deprived of his life, and according to the procedure established by law, there is a beneficial construction done in this case, and the law has been elaborated like anything. Then there is a rule of exceptional construction. So the reasonable construction, the word of statute must be construed so as to give sensible meaning. And exceptional construction is a situation where principle of statutory interpretation is used to interpret statutes in a way that deviates from the usual rule of interpretation. So this principle is used when the usual rules of interpretation, such as the plain meaning mischief rule, gives unjust result. For example, in Maharaja Singh versus State of UP, an exception to the same word, same meaning principle was made regarding the interpretation of the word West as used in UP Zamindari Abolition Act. When the lands and market, hats and bazaars vested in the state, the word connoted absolute ownership, effectively extinguishing property rights of Zamindar. When these properties later vested in the Gram Sabha, the term implied a transfer of administrative control or possession of local governance and public use, not full ownership. So you can see there are two different meanings which were given here. So when it was with the Zamindars, vested means when it was with the state, vested means it was within the complete control of the state. Whereas when it was with Gram Sabha, it was said that it is for use of public purpose, not full ownership, and Gram Sabha cannot sell that particular land to anybody else or a private owner. This is what is happening in case of Waqf also, you people must be aware about. So I think at this point in time, it is already 8:15. I should now take some questions. I think in this particular slide, we are left with a couple of 4 or 5 slides. So we will take them in our next class because it will be too much of interpretation for you today. I know it is a subject which is a bit of a lot of legal verbose is there, and I have tried to make it simpler, but if you read the interpretation, it is more difficult. More difficult words are used. For your purpose, if you look at your module, now what I will do is I will take questions from you. And if you can also raise your hand and ask the questions, I am also tracking your chat box. Let me see what questions you have brought there. Yes, there's a question from Kesapuram Kumari that can you give an example of without prejudice? So without prejudice is basically an exception kind of a thing. Like say, for example, I say without prejudice, you can discuss certain things with me. That means I will not judge you for that. That is called without prejudice. Without prejudice to the provisions, without prejudice to your safety, without prejudice to you being losing any marks, you can ask questions. So this is something, the term without prejudice. Okay. Let me check. Any other question I have? There was a long question. Yes. I think there was a question from Nidhi Vishwakarma. Okay. The rest of you also can ask questions. If you have any questions, please feel free to ask. I'm just opening the module from where the question was supposed to be asked. Okay, so there was a question which was asked by someone on this example. Okay, so this is General Clauses Act. So the question was with reference to probably this example. If I am not wrong, if you can ask the question again, please. What was the question with reference to this module on General Clauses Act? Please ask the question. I just missed your question somewhere. Without prejudice, basically, Anubhav means that without worrying about it or without application of that particular provision, I am making this statement. This is what is the meaning of without prejudice. Generally, in mediation proceedings, we say without prejudice. Without prejudice means this, whatever you say in this mediation will not be used against you for evidence. That is called without prejudice. Okay. So you are free to say the statement without prejudice. I hope that gives you clarification. Okay. Now, let me, any other questions? I'm not able to get the question on. Someone asked me the question on the module. Do you have any question on this module on General Clauses Act? Please ask. Yes, Astha, you had a question. Okay, right. Okay, that's a good question on repeal, Astha. So if you will see section 6 talks about repeal of provisions, right? So if I go to section 6 of your module, where is that? These are definitions. Preliminary. In your module, if you have financial year, calendar year, imprisonment, all those things. Then you have section 5, and then you have repeal. Okay, section 6. So you can see here where very clearly it is written, right? So wherever any central legislation or any regulation made after the commencement of repeals any act made or yet to be made, unless otherwise another purpose exists. This you have to read it very clearly. Unless another purpose exists. So whenever there will be a repealing provision, in the repealing provision, everything will be written very clearly. What has to happen? If the law has to proceed further, if the law has to stop there itself, if the law will go back, I will give you an example. For example, Indian Penal Code is repealed now. What happens to the cases which were registered before in the Indian Penal Code? Will be conducted under the Bharatiya Nyaya Sanhita? No, right? So the repeal clause will specifically mention that whatever action has been taken in Indian Penal Code will continue as it is. The new things or the offenses from 1st July 2024 will be under the Bharatiya Nyaya Sanhita, not under the Indian Penal Code. So this is how the repeal works. So it will be depending on the situation. Okay. So this is how it has to be. Right. Okay. 1.29. Let me see. 1.29. You have a question on 1.29. So I have to 1.29. Okay. Okay. In KG Krishnaiya versus State of State, 1959, it was held that it is not essential that same statutory authority that initiated a scheme under the Road Transport Corporation Act should also implement it. It is open to the successor authority to implement or continue the same. Okay, it is interesting. Okay, so what happens is in government, the things will keep changing. So, like for example, I'll give you one good example. So you must be aware that Planning Commission was taken over by Niti Aayog, right? Niti Aayog took over Planning Commission at one point in time. So can we say that whatever Planning Commission has started or was midway will be stopped, or Niti Aayog will have no jurisdiction to deal with it? Probably not, right? So Niti Aayog will continue with whatever scheme Planning Commission was doing it, and it will take over that. He's the successor authority, so it will take over, right? Similarly, when there was a company law board and then it changes to NCLT, what happened? Whether the things will stop there? No, probably the matters which used to be there in company law board will go to the National Company Law Tribunal as per the provision. So this is what it is trying to tell you about the successor authority. I hope it gives you the clarity, right? So, okay, is it clear to you? 1.29, this case is clear? Okay. Then 1.31, you have 23, 4, 1.31. Okay. 1.39, 1.31. What was that? 23, 4. 23, 4. Okay. 23, 4. The authority having power to make the rules or bylaws. This one you're asking? Or to be made within the sanction, approval, or concurrence of another authority, that authority also shall consider any objection or suggestion made by or received within the draft before it's so specified. So it is asking basically that if there is an objection which is asked for, they will consider those objections before applying. This is what I think. This is plain simple. Section 29. Okay. Section 29 saying saving of previous enactments, rules and bylaws. So it is basically when you say saving means saving of the previous enactments. So it says the provisions of the act respecting construction of act, regulation, rules, bylaws made after commencement of this act shall not affect the construction of any act, rules, regulation is continued or amended by an act, regulation, rule or made. What it is trying to do is any law which is repealed on a X date, whatever interpretation of that particular law has happened prior to will stand. It will not, dilute. So that is what the section 29 is trying to tell you. Okay. You have asked a question on 328. 328, what is that? 321, 328, 328, 26, and 27, and 328. Where is 328? It is 327. There is no 328. Where do you find 328? Astha, can you tell me the page number? I'll try to find. 1.34. Okay. Okay. Citation of enactments. Okay. Citation of enactments, it is basically, of not much relevance, Astha. I don't think that you will have any question on this particular part. But still, for your understanding, it is saying in any central act or regulation, in any rule, bylaw, instrument, or document made under or with reference to such act or regulation, any enactment may be cited by reference to the title or short title, if any, conferred thereon. Right? So where do you find the title and short title? I have given you in my presentation. You will find initially I have explained what is the title, what is the short title. So wherever you want to refer to that legislation, either you can refer it by way of the complete title or even the short title. Like for example, General Clauses Act, you can just mention General Clauses Act, or you can say General Clauses Act 19, whatever is the year. Okay, like that. So this is or by reference to the number and years thereof, and any provision in any enactment may be cited by reference to the section, subsection, or enactment. So it is basically saying that how to refer a legislation. If you want to mention a legislation somewhere, how do you mention? So it is of not much consequences. I don't think that there can be a question which can be framed on this. Okay. Any other question? Nidhi Vishwakarma. Okay. Thank you, Nidhi, for that input. What else? Pavan Kumar, you have any question? Section 23 and section 22. Give me page numbers where it is. Pavan. रिपीलिंग स्टैट्यूट्स, पवन कुमार, रिपीलिंग स्टैट्यूट्स का मतलब ये होता है कि अगर कोई भी कानून अगर रिपील होता है, अब आप हिंदी में मुझसे रिपील का मतलब पूछेंगे तो मुझे एग्जैक्ट वर्ड अभी नहीं पता, इफ एनीबडी कैन हेल्प. सो रिपील का मतलब होता है उसे खारिज करना और या उसे स्टैट्यूट बुक से हटा देना. तो जब आप किसी कानून को खारिज कर देते हैं तो उसके क्या परिणाम होते हैं, इसके बारे में हम बात कर रहे हैं. ओके, रिपील का मतलब ये होता है. तो उसका कहना ये है कि जब भी कोई कानून खारिज होता है, जैसे भारतीय न्याय संहिता जब आया नया, तो भारतीय दंड संहिता जो था वो रिपील हुआ, तो क्या इसके इफेक्ट होंगे, इसके बारे में ये बात कह रहा है. तो ये कह रहा है कि जो भी एक्शन भारतीय दंड संहिता में लिया जा चुका है या उसके एक्शन हो चुके हैं या उसका कोई केस पेंडिंग है, तो वो कंटिन्यू करेगा अंडर भारतीय दंड संहिता. रिपील का मतलब ये नहीं है कि वो कंप्लीटली खत्म हो जाएगा, लेकिन जो भविष्य में क्राइम्स होंगे वो भारतीय न्याय संहिता के तहत होंगे. तो मुझे लगता है कि आपको अब समझ में आया होगा. तो इसी तरीके से आप उसे पढ़ेंगे तो आपको समझ में आएगी बात. ठीक है. और अगर आपको हिंदी में और समझना होगा तो आप कुछ एआई टूल्स यूज करके उसको हिंदी में ट्रांसलेट करके समझ सकते हैं. ठीक है. Okay. 23. Okay. Any other questions? If you have questions, please put the questions in the chat box. I'm also seeing the portal in case you have there any questions there. No, I don't see any questions in the portal. Okay, if you people don't have any questions, you can say thank you and leave. If you don't have any questions, we will continue with the class on 9th. We will complete this interpretation of statutes. Okay. I have given you some homework. Do the homework and come. Point 2 of 328. Okay. Let me see. In this act and in any central act or regulation made after the commencement of the description or citation of a portion of another act shall, unless it different intentionally construed as including the word section or. Okay, so it is basically saying that if there is a reference, okay, so it is saying in this act and in any central act or regulation made after the commencement of this act, a description or citation. So second provision is with reference to pre-independence law. The first provision is reference to post-independence law. I hope this makes it clear. ठीक है, क्योंकि ये जो जनरल क्लॉजेस एक्ट है वो पुराना लॉ है ना, इंडिपेंडेंस के पहले का है, तो ये सब क्लॉज टू इंडिपेंडेंस के पहले के लॉ के बारे में बात करता है। अगर उनका कोई रेफरेंस है तो उसको कैसे पढ़ना है इसके बारे में बोल रहा है। होप दिस मेक्स इट क्लियर टू यू। ओके, okay then. Okay, so thank you and good night, all of you. See you on 9th. Okay. Yes. Thanks a lot for your support. See you on see you on 9th. Okay. Bye bye.